Again, hot, humid fans. Um, Today's article is about the American Bar Association. Mr. Bertling, 56, said in an interview that he had not heard what he considered sexist remarks in his decades of practice, but after the fine, he asked a lawyer in his office if she had. She showed him inappropriate comments in deposition transcripts that said she did not seek penalties for them because, like many female lawyers, she thought doing so was futile. As of this Monday, after months of debate, that may no longer be the case. Goodbye to honeys in court by the vote of American Bar Association. Now, this is Resolution 109, which amends the Rule 8.4, which is so legalese, of the ABA model rules. Professional conduct and discrimination and harassment will be legal ethics violations under ABA model rule. Now, that's a model rule, so where actually the rubber hits the road is probably not going to be anywhere near the same as the model rule. Here's another interesting piece of information to address objections by litigators who argued that the change could hinder vigorous representation of clients. The drafters added qualifiers. The amendment ethics rule now banned the offensive conduct only if the lawyer knows or reasonably should know it is harassment or discrimination and does not apply to illegitimate and legal advice or advocacy. This gives offenders some wiggle room to contend that they did not know their conduct or remarks were prohibited, unless, of course, they read the ABA minutes, which therein they cannot claim that. And any of these lawyers, if they have secretaries, the secretary should make sure that a copy of this ends up in their boss's desk. And they should actually ask in casual conversation if they read the latest ABA minutes. Wasn't that interesting? And comment about something else. And if they say yes, they can then testify in a deposition that the lawyer they work for knew that the ABA rule had been changed. Of course, whether this will actually happen, I don't know. But that's just kind of astounding. And someone made a wonderful quote. So, and Mr. Bertling said in the interview that he had not heard what he considered sexist remarks in his decades of practice. And someone's reply was, "Oh, sweetie." Yeah, because the reality isn't that he had never encountered them. A translation would be more accurate as Mr. Bertling, 56, had not ever considered anything he heard sexist in his decades of practice, which is different than him hearing something that's sexist. He probably heard sexist things hundreds and hundreds of times. He wasn't concerned about it because it wasn't aimed at him or any lawyers that he cared about, i.e. men. So who cares if it's sexist? No big friggin' deal. So that's how these kinds of processes are perpetuated. Year after year, decade after decade, generation after generation within law firms, within legal systems, public defenders' offices, judges sitting on the bench who can get away with anything they want, pretty much, because they're judges sitting on a bench. And they can be sexist as the day they want, as the day is long, because any woman that comments about it could be barred from ever being a solicitor in their courtroom again, or could be hit with the perjury charge. So who's going to talk back to a judge in their own court? Nobody. So judges have carte blanche to do anything they want, say anything they want, offend anyone, and no one can do anything about it. The system needs to have accountability built into it, and a model rule is nice, but it shouldn't be a model rule. It should just be a rule, and it should have some friggin' teeth to it. And I don't think this is going to. I mean, it's a step in the right direction, as I mentioned in the title. It's a teeny little step, but it's a step in the right direction. At least the conversation has been opened. And as someone else notes in this discussion, the fact that no lawyer signed up to speak against the revised rule makes me feel hopeful that at the very least, people who hold misogynistic views are no longer comfortable voicing them in a professional environment because it finally stands a chance of reflecting on them poorly in a way that hits them where they hurt. So it's not so much that you're changing the hearts and minds of misogynists. It's that you've now let them know if they are publicly misogynistic, there could be ramifications to their career. Because heaven forbid they were known as a misogynist and step in front of a woman judge, or they have to deal with a woman litigator. So they at least have to give the impression that they are neutral on the topics of sexism. What they do in their private life is something completely different. But at least maybe in their personal, rather than their professional life, they will act in a more appropriate manner and stop being blatantly and horribly misogynistic. But I guess we'll find out whether this works or not, whether a model rule has any chance of changing the system, or whether they need to actually, sit down and realize that we have to face this directly. We have to stop talking around the problem. But let's face it, who likes to talk around a problem better than a lawyer?